Good afternoon, Judge Irwin. My name is Lisa Woodard, and I represent Wisconsin residents Mr. Joyce and Mr. Voigt in this matter, against the defendant PepsiCo. This case also involved co-defendants Wispac Inc., a Wisconsin company, and Carolina Counters of South Carolina, who were equally served, yet did respond within the time frame. Your Honor, thank you for the opportunity to respectfully respond to Defendant's Counsel, Mr. Elizadeh, in his request pursuant to Federal Rules of Civil Procedure to set aside your final default judgment under Rule 60B. Mr. Elizadeh referenced improper service as his primary argument underlying his motion. While he accurately noted a foreign company that transacts business in the state shall have a statutory agent upon whom any process notice or demand may be served, the legislative intent was to better afford access for Wisconsin plaintiffs to companies doing business in our state from the far corners of the earth. While PepsiCo is certainly a global company, it is not a foreign company operating in the U.S., as it is incorporated in North Carolina and is headquartered in New York. Although PepsiCo's agent may have been served, this would not have been required by law, and service to its incorporated location of North Carolina was a perfectly appropriate option under Rule 4H. Mr. Elizadeh claims the judgment amount fails when compared to the incurred cost to my client. However, quite the opposite is true. Put into perspective of my client's opportunity loss cost, the amount is merely a drop in the water bucket compared to what PepsiCo has gained by distributing Aquafina bottles by the tens of billions at likely a very high profit margin per bottle. Lastly, PepsiCo requests the judgment be set aside in order to put forth its meritorious claims and defenses. Well, the time to have done so is past. To prevail, the movement must establish that the mistake was understandable or even excusable. According to Pepsi's court documents, a legal secretary who was busy preparing for a board meeting set the documents aside. Is this court to believe that a company like Pepsi with $63 billion in annual revenues does not have a systematic process for proper handling of legal documents appropriately delivered to its location of incorporation? While mistake, inadvertent surprise, or excusable neglect are addressed in Rule 60B, this is a situation that should have never been subject to human error, and perhaps maybe was an effort to make my clients have to work pretty darn hard. This judgment is important on many levels. We believe that in the end, as an officer of the Wisconsin courts, you'll withhold the judgment and award our clients the damage they deserve. Your Honor, the judgment you renders against PepsiCo was fair, just, and should stand.